drug paraphernalia, reckless driving by intoxication, and you have a separate indictment charging you with possession of methamphetamine on a misdemeanor basis. You have the right to an attorney. Do you want a lawyer to represent you?
Yes, Your Honor.
Okay, I'm going to appoint the public defender to represent you.
Wait, before we read the indictment, enter a plea of not guilty.
Plea of not guilty is entered.
Judge, can we put this on June 30th? We think we have a tentative agreement. If it doesn't work out by then.
We'll move it to June 30th. Your lawyer wants to talk to the district attorney about your case, and then we'll see if you can resolve it on June 30th. If not, we'll give you another day. Thank you.
William Keaton Hall, page 7.
You know, Mr. Hall's case, a public defender's officer represents Mr. Hall. There is had the one motion that went through, whatever, but we still haven't had a standing motion that I assume we want to hear before we set it for trial. That has not been set, so we need to, I would say, get a date for that motion.
How quickly can we hear that motion?
I don't know how quickly we can wrangle.
What is the nature of the motion? This is one Mr. Mitchell had filed, is that correct?
Sorry.
Mr. Mitchell through Mr. Clemens, it's some kind of jury instruction, constitutionality issue. But anyway, I would say we would want to hear that before we set it for trial.
Well, and that's why I'm wondering, depending on what these motions rule in the Heman case, we may have several days in the next week, this week, that we could argue those motions.
I mean, I could reach out to General Crouch, see if he's available. I'm sure.
For this week, I don't know if Mr. Mitchell's available.
Mr. Flanagan, did you ever locate your client in Heman?
Judge, he is about 30 minutes away, and it's my fault. He knew he had a trial starting tomorrow. He misunderstood about the motion, so he'll be here in about 3 minutes.
He said Mr. Mitchell not out of town.
I think he's leaving to be out of town on Thursday, Your Honor. I can text him to confirm that, but that's fine.
Well, did he give you any idea? I mean, we need to set those motions, and it seemed to me we need to set them before. We haven't set this Hall case for trial, correct?
No, we have not. We were waiting for that other, which is passed, and now we have that one set. And it's the only motion pending. So,
you want to set it and set the motion in October and then set the trial.
That's fine, me, Judge, and I will speak for the state just for the motion purposes. I don't mind hearing about a county. I don't know if they will object to that, but if that's easier for Your Honor to get us a quicker date.
So I can get you a quicker date if we hear it out of county. If you want to come to Dickson County, we can hear it on.
Certainly that's easier for General Crouch, and doesn't matter to me, Judge.
I don't know. I can ask Mr. Mitchell. I wouldn't think you would have an objection to that, Your Honor. But
if you want to give us a preliminary date, I can reach out on my end.
Look at the 23rd of September.
23rd of September.
That's in Dickson County.
I'll reach out and we'll quickly second call, Judge.
I'll reach out to Mr. Mitchell, Your Honor.
22nd.
The 22nd of September.
Yes, sir. Think so.
I have Dickson County, September the 22nd is Dickson Chancery. The Godwin trial is the 24th of September. So I'm looking to see if we have any dates in July. I have Houston County case that we have moved to Dickson County to argue state versus Estes motions in Charlotte on the 17th of July. Any possibility we could do that?
What was the date, Your Honor?
July 17th. There are motions in the state versus Estes, a Houston County case, and it's going to be heard in Dickson County. So we could hear these motions or the motion in the Hall case on the 17th, if that would work.
I'll send both those dates to General Crouch.
All right, let me know. All right, Mr. Hall, we're going to pass you until we can get a date. Your lawyer will have to let you know when those dates are, but we're working to try to get a hearing on your lawyer's motion as quickly as possible so we can try to get a trial date. All right, thank you.
Thomas
All right,
Gammon,
Dr. Jones.
page 7.
This is just an arraignment on superseding indictment.
There's a superseding, the state of the defense actually filed a motion to withdraw as well.
Yes, Judge, and the basis for that motion would be that it had come to light that we currently represent another gentleman on a related case. This is a drug transaction. We represent the other party to that transaction. And so I think that would likely be a conflict of interest.
We have,
Sure, this is actually not a drug sale or,
I'm sorry.
this is not a drug sale or anything with a code in.
Well, in reviewing the discovery, I believe that he's charged with, in case number 15240, I don't know about the superseding indictment, but I
That
read-
changed the changing next up to dates.
Okay, well, he's charged with knowingly possessing methamphetamine with intent to resell. We represent the person who in the discovery appears to say with alleged sold in those drugs. So
That there's no allegation that he was sold, that say he was sold. He could have made it. We didn't allege anything with any other person.
I don't really care one way or the other if I get off the case, but I felt like, if maybe, for example, in the defense, it might be advantageous to.
I'm going to deny your motion to withdraw right now based on the fact that it doesn't appear that there's an actual conflict. But if we get into it and you discover that there is a conflict, you're free to renew your motion. I just need something more substantive than that. State's position. Go ahead.
If I just put this on the record, where my mind goes is it would be something that I would consider doing in an ordinary case, trying to make some sort of proffer agreement against maybe another bigger fish in the drug trade, let's say. And so that was the main substantive reason that I thought, okay, even though he's not directly involved, I feel like I can't be like, hey, state, my guy can testify against this other guy.
Well, if you get into that situation, Mr. Sensing, and you discover that that is going to be an issue, then feel free to revisit it. But
Understood.
we have such a limited number of attorneys. I know there's a bunch of them sitting over here, but many of them take these appointed cases out of an abundance of caution. I would rather wait and see if there is going to be an actual conflict.
Yes, Judge, I understand.
Proceeding.
Well, we have the superseding indictment from Mr. Hannah as well.
On behalf of Mr. Hannah, we waive formal reading and enter plea of not guilty.
Being not guilty is entered. Do we have a status date already set?
Today was the status statement.
You know,
What day, Madam Clerk?
Today was the original status day,
I
so
assume
we'll
it needs to go to
October the
October
6th.
6th.
October 6th.
Thank you.
All right, Mr. Hannah, your lawyer will be able to talk with you about this scenario. Thank you.
Baker Sean Harden, page 7.
Mr. Harden, you're here to be arraigned on a charge, an indictment charging you with aggravated assault. You have the right to an attorney. Do you wish to have a lawyer represent you?
So I already have an attorney downstairs. I haven't even spoke to an attorney. I went to court like 2 months ago. I've been in jail for 6 months, and I got a June 9th court date for my probation. They kept it downstairs.
Judge, I think Lindsay York representing this.
All right. Was your attorney down in the lower court named Lindsay York?
Yes, sir.
I don't know what conflict code since I don't remember, but it doesn't matter.
I can't remember what it was either, but
the
he,
victim you
I think it may have
represent.
been the victim.
All right, I'm going to appoint Lindsay York to represent you again at this level. And I'm going to go ahead and advise you of what the charge says. This is in the Circuit Court for Humphreys County, Tennessee at Waverly, June term, grand jury 2026. The grand jurors of Humphreys County, Tennessee, duly elected and paneled and sworn, do find that on or about December the 27th, 2025 in Humphreys County, Tennessee, Baker Sean Harden did unlawfully, intentionally, and knowingly cause Rodney Priest to reasonably fear imminent bodily injury by use or display of a deadly weapon, a machete, in violation of TCA 3913-102, a Class C felony, all of which is against the peace and dignity of the state of Tennessee, signed W. Ray Crouch, Jr., District Attorney General. Show that Mr. Harden has been arraigned. Ms. Lindsay York will be appointed to represent you, and we'll send her a copy of that. What status day do we want to set?
Sir,
They're gonna set your status date.
I didn't hear you say.
They're gonna set your status date.
My what?
You reset it.
I didn't understand what you said, Kirk.
All right, I'm trying to get you a new court date. So district attorney want to give me a new status date? What, July 14th? All right, your next court day will be July 14th. Your lawyer will be notified and she'll be in touch with you.
Okay.
That's
Oh,
next
thank you.
month.
All right, thank you.
All right.
Billy W. Jamison, page 9.
Mr. Jameson, you're here to be arraigned on a couple of different indictments. You have an indictment charging you with a Schedule 2 possession of fentanyl of 0.5 grams or greater. Then you have another indictment charging you with a number of different drug charges, including possession of methamphetamine with intent to sell fentanyl 0.5 grams or greater. You have Schedule 2 drugs, possession with intent, tampering with evidence, introduction of contraband in a penal facility, possession of drug paraphernalia, and possession of drugs without a prescription. To all of these, you have the right to an attorney. Do you wish to have a lawyer represent you?
Yes, I do.
Have you had a lawyer appointed before today?
No.
They would not appoint in general sessions because Mr. Jameson indicated that he had money from a settlement. He was arguing that in order for a bond source. And then so the judge said if he had that money, she would not be.
Mr. Jameson, are you able to hire a lawyer?
I currently am not.
He did write a letter later. Mark Atchison was originally appointed in general sessions and then taken off based on that.
All right, I'm going to appoint Mark Atchison to represent you since he was originally appointed. He has a junior associate here, Mr. Baker. Do you mind standing in for Mr. Atchison?
Mr. Atchison, you're right.
Oh, there he is. I'm sorry.
Too high.
The left doesn't know what the right is doing. All right. Mr. Atchison, you wish to have a formal reading of the indictments in this?
Judge, I'd wait for a reading, enter clear not guilty.
Clear not guilty is entered. Status day, please.
7/14, Judge.
July 14th for status. All right, your lawyer is here. He's been given a copy of the charges. He'll be up to talk with you when he can.
All right, thank you.
Thank you.
Byron Notorious Jones, page 9.
Mr. Jones, you're here to be arraigned on a probation violation warrant alleging that you have never reported after being placed on probation on March the 31st of 2025. And you were on probation for 11 months and 29 days. You have the right to an attorney. Do you wish to have a lawyer?
Yeah.
Public defender?
Here, plead not guilty, Your Honor.
Plea of not guilty is entered, set for June 30th. We're going to bring you back next week. I guess it is next week, right?
Yes, it's Tuesday.
2 weeks. It'll be 2 weeks from now. We'll have you on June 30th to have a hearing in your case. Thank you.
It's next Tuesday.
Next Tuesday.
Is this next
Yes,
Tuesday?
it is.
The next one,
Next
third.
Tuesday.
Michael
quick.
Dean, I'm sorry.
It's all right.
Michael Dean Marlar, page 13.
Marlon, you're here to be arraigned on an indictment charging you with domestic assault, interference with emergency calls, false imprisonment, and evading arrest. You have the right to an attorney. Do you wish to have a lawyer? Do you want a lawyer, Mr. Marler?
Yeah, Justin Sensing.
Justin Sensing. All right, Mr. Sensing, you've been requested by name, so we'll appoint the public defender to represent you.
Yes, Judge, we acknowledge the appointment as well as receipt of the indictment, waive formal reading and enter a plea of not guilty.
Plea of not guilty is entered. Status day, please.
Judge, you got something set on the 30th, so you put it on the 30th.
All right, we'll move it to June 30th. That's next week, right?
Yes, sir.
Yes, Your Honor.
Right.
Thank you.
Rodney W. Priest, page 15.
I got this.
All right. Mr. Priest, you're here to be arraigned on an indictment charging you with making false reports to a police officer, aggravated 911 calls in a non-emergency situation, and driving on a revoked license. You have the right to an attorney. Do you wish to have a lawyer?
Yes, sir.
Public defender?
Wait for him reading the indictment here, plead not guilty, Your Honor.
Plea of not guilty is entered. Status day, please.
Judge, he looks like he's got something set for 30th. So put this in mind.
June 30th will be your next hearing. We'll see you next week. Thank you.
Yes, sir.
In the hallway. Eddie Dwayne Roney, sorry.
Ronnie or Roney?
Ronnie.
Roney,
Mr. Waynick, do you represent Mr. Roney?
I do, Judge. I think we filed a notice of appearance. But anyway, we'll waive formal reading, enter a plea of not guilty.
Plea of not guilty is entered. Your lawyer is here in the courtroom, as you see, and has entered a plea of not guilty for you. So we'll set a status day of
July 14th, Judge.
July 14th. All right, your lawyer will be working on your case, and we'll see you on July 14th.
Thank you, Judge. I think I'm in Texas on July 14th.
That's between you and Judge Lockhart and
Judge Wallace,
Judge Wallace.
7/28 is BOP day.
That's
You'll put it on
fine.
7/28,
Yeah, that'd work great.
July 28th.
Thank you, Judge.
Spencer D. Stanfield, pages 17 and 18.
Judge, we need to move that to 6:30. An offer's been made and I need to come down to the jail to talk to him. Mr. Stanfield, can you hear me?
Yes, sir.
I'm gonna be down there later today to talk to you.
All right, thank you.
Lay the office.
All right, June 30th.
Thank you.
Samantha Lynn Gardner, page 6.
Ms. Gardner, you're here to be arraigned on a violation of community corrections warrant. You have the right to an attorney. Do you wish to have a lawyer represent you?
Yes, sir.
All right, I'll appoint the public defender to represent you. Here's a copy of that if you want to. Set for June 30th for hearing. If you need more time, you can let us know then. We'll see you next Tuesday.
Tabitha Jane Scarborough.
Barbara, you are charged here with apparently with possession of or driving while you're in possession of methamphetamine, as well as possession of methamphetamine with intent to deliver. You have the right to an attorney. Do you wish to have a lawyer represent you?
You want to point it to me?
All right, I'll appoint the public defender to represent you. They're here in the courtroom. They've been given a copy of your charges.
Wait for him reading the indictment, enter a plea of not guilty.
Plea of not guilty is entered. Status
July 14th.
July 14th will be your next court date. Your lawyer will be up to talk with you. Get you ready.
Okay,
Thank you.
thank you. Jennifer Renee Smith, pages 16 and 17.
This is Miss Lowe's case.
Yeah, see your judge's motion. We passed that.
She's down here.
All right, so we just need to pass Miss Lowe, the,
Counsel has no-
put it on the second call, General.
Yes, sir. Please.
All right, we're gonna put you on the second call. Ms. Smith, your lawyer is downstairs, and as soon as we can get her up here, we'll take care of it. Thank you.
Thank you. Stephanie Danielle Sims.
We'll take 16. Sims, you're here to be arraigned on an indictment charging you with possession of methamphetamine with intent to distribute or deliver. You're also charged with possession of drug paraphernalia and tampering with evidence. You have the right to an attorney. Do you wish to have a lawyer represent you?
Yes, sir.
I will appoint the public defender to represent you. They're here in the courtroom, and I've given them a copy of your charges.
White Palmer in the indictment entered pleaded not guilty.
We are not guilty as entered status.
July 14th.
July 14th will be your next court date. Thank you.
That's all for our Zoom. We have two to bring up, Miss Lombardo and Marvin Northington.
Good. All right, we'll go back into the regular docket. We have to remember what it was.
The last one I remember.
I think,
I'll take the parents ran. Oh, you got through Hayden Shackle. And they gave us one, so that'd be Lisa Cook.
all right. Docket number 15259, State versus Lisa Lynn Colt. You're here to be arraigned on an indictment charging you with possession of methamphetamine with intent to deliver, possession of drug paraphernalia, and driving while in possession of methamphetamine. You have the right to a lawyer. Do you wish to have a lawyer represent you? Are you able to hire a lawyer of your own choosing? Raise your right hand. Let's place you under
You
oath.
solemnly swear or affirm that the testimony now given in this case to be the truth, the whole truth, and nothing but the truth, so help you God.
I'm going to give you an affidavit that you have to fill out. You need to sign it under oath and make sure it's accurate because you will be signing it under oath, and we'll come back to you to determine whether you qualify. Docket number 15208, State versus Avon E. Curtis. Mr. Flanagan.
Judge, Mr. Curtis is here. That's the case that we're trying to get resolved. I don't want to put everything on second call because I know you need to leave at 4, so we can just put it on 6:30 to give me a chance to talk to you.
Already I did that.
Anything you don't get to the various ranks, you make it clear, you just need to,
I'll be.
June 30th.
I don't know, that's statute.
June 30th. Good job.
Let me know when Mr. Heeman arrives.
He's about 15 minutes away. I did tell him what's going on. He's waived his presence. He can take it up.
All right, let's take it up. I want to deal with this Heeman case.
Yes.
Were we ready on the Heeman case, State?
He's about 15 minutes away. He knows what's going on.
All right, we have a couple of different motions. The first motion is the first amended, we got a motion to dismiss, and then we also have a motion to suppress, the first amended motion to suppress the blood evidence. And we had a pretrial conference on this, and I want you to state your position regarding these motions, and I want to hear from the state.
Well, on the motion to dismiss, my position is it can be filed anytime prior to trial. We're attacking count 1 of the indictment as being faulty. And ask that it be dismissed is something the court would have to rule on prior to trial. And we think under the rules, it's timely filed. We can file it anytime.
It was filed yesterday.
It was filed yesterday. And that's our position on that. On the motion to suppress, the original motion was filed some time ago, and it was kind of a bare bones motion that's been amended. That was just filed yesterday. And we concede that that motion would require the state to have a witness for that motion to be argued. But again, we think that even though it was filed yesterday, we can file it anytime prior to trial. So that's our issue on the 2 motions.
All right, let me hear from the state.
Just before you do that, do you want to, we did bring up another oral issue. Do you want to address it first?
No, yeah.
Judge, I'm also, this occurred on Loretta Lynn's property, the famous Loretta Lynn. I'm concerned about publicity. So I'm going to make an oral motion, which I did in chambers, to sequester the jury. and I will waive any other argument on that. So I just want to get that on the record. I also want to reserve the right, when we go to picking the jury, reserve the right to move for change of venue if that becomes necessary. That's premature, but I just want to put that on the record.
All right. Mr. Hornet,
Judge, I want to take it a little bit out of order. I think Mr. Flanagan did address the motion for a sequestered jury orally. I think logistically at this late date, that's not possible. So we would object to that. I'm going to go to the motion to suppress, then the amended motion to suppress, which was filed yesterday, as we discussed in the pretrial conference, Your Honor, talking about timely filing and those types of things. I know Your Honor did. I did some quick research yesterday afternoon. I think state would have to admit they were timely filed pre-trial, which is what the rules of criminal procedure say. However, the amended motion to suppress greatly expanded the original motion to suppress and would require some additional witnesses that we were unprepared for based on that argument. Defense counsel in chambers did tell the court and us what we were dealing with, but in doing that, we will have to track down a witness, get them subpoenaed, and we can't do that before tomorrow morning. We don't believe it'd be proper to do it during the trial, because if you ruled against the state, obviously a suppression would change us in our position. Ruled against Mr. Flanagan and his client, Mr. Heeman, they obviously would probably, or at least ask for some type of interlocutory appeal. So we think that the only option would be to continue the motion. If it's going to be heard, we would say it should not be heard, but if it's going to be heard, we would ask it to be continued. As far as Mr. Flanagan's motion to dismiss count one of the indictment, if we're going to continue the motion and amended motion to suppress, the state would ask for a continuance in the motion to dismiss the indictment. We can either file an oral motion at some point or supersede or file a written motion, clear it up, because we're not going to have a trial before at least October. We have at least one grand jury between now and whenever this will be set. So we would ask that be continued. What's good for the goose, kind of good for the gander, statement. So,
Ms. McLeod, anything to add?
No, Your Honor, I agree with you.
Right. Well, first and foremost, the right to sequester jury is within the discretion of the court. And typically we reserve that for a case involving a first degree murder because of the serious nature of the charge. Of course, I think the homicide is also a very serious charge. In this particular case, the court is of the opinion that there has not been shown to this court's satisfaction that a sequestered jury is necessary to preserve the defendant's right to a fair and impartial jury trial. And as a result of that, I'm going to deny the motion for a sequestered jury, but reserve the right of the defendant to come back in and renew that request if in fact there is difficulty shown in the selection of a jury. The same thing goes with the right to a change of venue. Typically, a change of venue would only be granted if it's shown to the court's satisfaction by evidence that there is such publicity and such knowledge and attitude within the general community that a jury of impartial jurors could not be selected. Typically, we deal with that. Absent some showing, we would deal with that at the jury selection process, and we actually have had that happen where we start the jury selection process and can find a jury that is free of any sort of pretrial publicity and information, and then we stop and transfer the venue to another county. But right now, I'm not going to grant a change of venue absent some showing, but I'll allow you to renew that if we start the jury selection process and have difficulty in selecting. Then moving to the two motions, the motion to suppress, the amended motion to suppress, and then the motion to dismiss. The court is of the opinion that the rules, criminal procedure, Rule 12 specifically provide the following. Pretrial motions under subsection B of that rule, motions that may be made before trial. A party may raise by pretrial motion any defense, objection, or request that the court can determine without a trial of the general issue. Section 2 of subsection B states motions that must be made before trial. The following must be raised before trial. A motion alleging a defect in the institution of the prosecution, which would be our motion to dismiss, I think, paragraph or count 1. A motion to suppress evidence. Obviously, that is also dealing with one of the other motions. Those and other motions regarding discovery. Unless otherwise provided by local rule, the court at the arraignment or as soon thereafter is practical and the deadline for the parties to make pretrial motions. Nothing in this rule prohibits a defendant from filing a motion that we've dealt with in this case prior to the trial. Monday was prior to the trial. The trial was scheduled to start tomorrow, so therefore the motions that have been filed by this court's determination are timely filed under the rules of procedure. As a result of that, and result of the amended motion to suppress the blood evidence, it's my understanding that that would then contest, based on statements of counsel during our pretrial meeting, that part of that is going to involve the contest of the actual drawing of that blood sample that was taken, and therefore it would require the state to introduce evidence of the technician who took the blood sample to determine whether they were qualified under the law. As a result of that, it seemed to me that in fairness to the state, they would have to have an opportunity to bring in those witnesses and go from there. The second motion to dismiss, the other motion rather, being a motion to dismiss, alleges a defect in the prosecution by the language of the indictment. And this court is of the opinion that the state would have the right to amend that indictment to, since this case is going to have to be continued anyway, to allow for the state to obtain the witnesses necessary for the blood draw question to be addressed. That I'll have to give the state an opportunity to do that, and as a result of that, the state would have the right, in any event, to amend the indictment. And if it's amended over if I grant them the right to amend the indictment over the objection of the defense would have the right to a continuance anyway. So both sides, in my opinion, would be entitled to a continuance, whether this court likes it or not, to grant that. So I am ordering that the case will be continued. We now need to address setting these motions for hearing. I assume we can't hear them tomorrow, Thursday, or Friday, correct? You can't get your technician here on that day.
I don't even know who it is, Judge. I have to find that out first.
Don't know who he is, so you're gonna have to find it out. Okay.
And track of day.
I had given you some dates. We could hear this date on July 22nd, hear these motions on July 22nd in Dickson County. I assume you've got a judge in July, right?
Said 22nd.
22nd, that's a Wednesday.
I'm sorry, I thought you'd given us 20.
I had, but this is a new date. I'm
Judge, I can't do the 22nd. I have a trial with Mr.
all right.
Brad.
Then I had given you the 17th of July in Charlotte again.
I am in Chicago. Training.
I thought you were going to Texas.
Wayne's schedule.
That was, I know, I said Texas earlier. That's in August. Yeah, but I'm in Chicago actually.
They were talking 17.
Yeah, I was talking about the 17th of July, but apparently Mr. Waynick is not available.
I mean, that's been paid for and everything. It's not a vacation, it's training.
Yeah, right.
We could do the 17th. Yeah, Mr. Planning could.
Well, I was going to play in the municipal golf tournament, but I'll pass on that. Since I got a bum.
23rd, Judge.
Are you here the 17th?
I cannot do the
I'm not here
23rd or
the
24th of July.
23rd.
No, I meant of September.
September the 23rd.
we talked about that for the homicide trial hall motions.
Well, I had the hall.
We didn't set it to 23rd. You gave us that date. We're checking with everybody.
I'm in Dickson.
That's Dickson criminal docket, and there's only 2 dockets that month.
Oh, that was,
That's due to, I think she is correct. We have 2 criminal dockets that month, and so that's probably likely.
is out.
The 23rd would probably be out.
Okay.
What about, Mr. Kenny, on the 14th of August? Is that a trial that's there? I've got State versus Billy Ray Perry, Paul Dubois motions, Mr. Spratt and Mr. Brown.
That's Judge Lockett Mash's criminal plea. And
That's our docket call here.
Yeah, those motions are filed. We're gonna hear those that day, probably. I think there's a September status for that, Dubois and Perry, but I don't suspect that's settled. So the August date is the one I think we'll be proceeding.
All right.
I like that time, that's sure.
Well, I don't see any other open days other than the criminal docket day here on October the 6th.
I don't show that any criminal trials are set the 7th and 8th yet.
I just get docket to go.
Do what?
Still got a pretty good docket to go.
Yes. And I just want to throw this out. I am supposed to be going in front of Judge Woodruff on a trial in Williamson County. That's a long way out, but
Which game?
October
We
6th.
have a DUI set
On
already.
the 7th and 8th.
All right. We do have a DUI set on the 7th. Is that correct? No, that's here.
Yes. I see for the whole month so far, but I mean, we have set stuff. I'm not sure what's that stuff. Right today.
And the conspiracy cases are all set in Dickson County on the 19th through the 23rd of October.
What case you're on, sir?
The 100, well, we had 20-something defendants in a conspiracy case that we set the remaining ones for the 19th through the 23rd.
I mean, that trial good.
So we want to do the 6th? Is that the day we booked or not?
I guess we'll just have to do the 6th of October for the motions, and then we'll just select a trial date then, or do you want to go ahead and set a trial date? I would say, well, let's go ahead and set a trial date.
I'm fine with that, Judge. I didn't figure you had your February docket here.
Oh, we've got a tentative February docket. So.
Tentative away. It's just, that's what it'll be anyway.
So I would be in Humphreys County and tentatively, trial date could be the 10th and 11th
3 days.
and 3rd and 12th,
Hold on.
February of 2027. Still gonna be practicing there.
Well, I mean, the actuarial tables suggest that'll be close, but.
Got 5 good years still there.
On that.
That's about it. Those 3 days.
Yes.
I don't have anything set that day, just waiting, maybe you have family. Apparently.
Where are you gonna be in February? What county, state, location?
I don't know yet. I'll come on to something. Let's go ahead and pencil it in.
All right, I am setting the Heman vehicular homicide case for trial on the 10th, 11th. We're gonna tentatively, we've set the criminal docket here on the 9th of February. And on the 10th, 11th, and 12th, we will have the Heman vehicular homicide case.
Yes.
We'll go to trial on those days.
Yes, sir. Thank you.
So Judge, just to clear it up, we had talked about the 23rd for the Hall motion, that's out, right? Of September.
Let me look.
That was the date that you gave back in September
But then you
17th.
said that's only one of your 2 docket calls in Dickson, which are usually 400 pages. These things.
Yeah, I mean, the dockets in Dickson are huge, and I thought we might be able to do it on that day, but.
I understand. I'm just confirming, trying to confirm the 6th. We had the 23rd clear, but we're now reaching out for the 6th. Make sure.
So nothing on the 17th of July.
No.
Okay.
But I don't think Mr.
Oh,
Oh,
goodness.
no, Mr. General Kraft is not available. on
Okay.
17th. I think he
When we take a break, I'm gonna make some calls regarding the schedule in August, and because I have Stewart for the first 2 weeks and Houston the second 2 weeks, and I will see if I can determine if there's any trials that are, there may be some days that are simply not set, and that may open up some days for us to try to get those Hall motions. So,
Okay, not the 6th is good with General Kraft and Mitchell. So
yeah, I mean, we'll just see what we can find out.
if we can.
All right, then we're ready. We'll just pass the Hall motions, but we've got the human vehicular homicide now set, so we can go back to calling the docket.
So we're going with 6th then on Hall.
Right now, we're gonna do October the 6th on Hall unless I can get you an earlier
Yes, sir.
date in August. All right. It would appear that the next case I have is Colton Gregory Damesworth on page 5. Let me know if I skipped, pardon me if I
I'm not
skipped
sure
one.
where I'm at.
Mr. Flanagan.
He's here, Judge. We'll need a trial one day.
All right, this is going to be set for trial. Mr. Damesworth understands that if we set it for trial, he is going to either go to trial or plead to the indictment and go to sentencing.
You understand?
State would suggest a trial date of October 8th. That's February.
October 8th.
Yes.
All right, 15087 State versus Brian Lee Davis. Mr. Wainick.
State's made an offer.
All right, so you're not going to be able to settle this case. You're going to get a trial date, and we'll either go to trial or plead to the indictment. Right?
Or if we need it, right.
Plead to the, every count of the indictment and go to sentencing is what would have to happen. All right.
But I don't know if we want to set it now, or do you want to pick another date to set? I don't know what you want to do.
Well, I don't know. It's not my case. I mean, it is my case, but it's not my
Well,
client.
certainly, yes.
So is there some, this is a case, state's going to have to tell me, do you want a trial date or do you want to have another discussion?
Judge, I've got approved for another discussion.
Let's put it on 6:30. See if you can't resolve it. If you can't resolve it on by that time, that'll give you another week to see if you can work it out. If you're not, then we'll set your trial date. Docket number 15069A, State versus Candy Diaz.
Judge, I represent Ms. Diaz. She's actually got 2 cases on the docket. I believe it's 15238, Judge. That indictment just came out of grand jury in April. Your Honor, I was already appointed to her original. And Judge, I did file a motion to dismiss the newest indictment. But if it's okay with the court, it is present. If it's okay with the court, I know this is General McLeod's case. She just got back. There's a new indictment. She's been arraigned on it, been appointed to that one. So if we can get another status there, I'd be okay with it.
Judge, I want to start having an issue with all these attorneys blaming me, saying I just got back, but I've been here a month and already had a jury trial. Just want to put that on the record.
Who is this behind you?
Candy.
This is Ms. Diaz.
Wanted to make sure we didn't tase her or whatever. All right, so let me say this. General McLeod has been back and hard at work for at least a couple of months because I've had her trying cases in front of me.
Duly noted.
So all of you who say, well, gosh, I just didn't want to bother her while she was out for maternity leave, that ends today. So,
All right.
now, by the same token, obviously, if you need more time, I want to make sure that you've had an opportunity because I know lawyers are busy. I guess we'll put it on October the 6th for your final status day. And if you're not able to resolve it, we will set it for trial on that day.
Judge, he filed that motion to dismiss on 6/17. There's no notice of hearing. I'm assuming you want to hear that on the 6th.
We can hear it on the 6th, Judge. Might as well keep them all together.
All right, your motion to dismiss will be heard on October the 6th as well. And obviously, depending on what I rule on the motion, then we'll know what we're setting for trial.
And Judge, Ms. Diaz does have some matters in juvenile court, so I do anticipate filing a separate motion as it relates to the conditions of release, the bond conditions. But I'll start. Thank you, Judge.
I put this on October 6th.
October 6th.
Here we have docket number 15069B, State versus Quincencio Diaz Acosta, and you're saying you could not get an interpreter.
No, sir, but we did have an interpreter that came in and spoke to him over the phone that deals with him often. He's claimed on 3/19 he had hired Seth Chapman, an attorney out of Springfield. And I have not received anything that I know of. Let me double check.
All right, I'm going to put this on June 30th, and
Yes.
if you will notify, if we can research and find out from the attorney. if
This
in
is
fact-
Mr. Acosta Diaz as well. And I do know he does understand English.
¿Se habla inglés? Un poquito? Okay. Do you have an attorney? What is his name?
Chapman.
Who?
Chapman.
You have his card?
Yes.
Judge, what's his defendant's name? I'm texting.
Quincencio Diaz Acosta.
Next up here.
Did you give him dinero?
La mitad.
Part?
I paid 2,000 and the camera.
So he should be here. All right. We'll show Mr. Chapman as his attorney.
Have to give him information. So
Then let's go ahead and you want to go ahead and set a final status date, General?
That's General McLeod, so if we could do October 6th.
I think that's when the code defendant was set.
All right, October 6th. Do we have something we could write that down?
I can write it down, sir.
Unless you want to do a different date.
October the 6th.
Please report, Your Honor. I'm going to send Mr. Chapman a text right now with that date.
Well, he's gonna get one from several people, but everybody get out your phones. Everybody, let's just all send Mr. Chapman a text message to say he was supposed to have been here.
It's like a son.
I appreciate how lawyers try to cover for each other, so. All right, October the 6th. Docket number 15260, State versus Christopher Todd Dotson.
He has got one for an arraignment judge. The others are set for 7:31 for status. I've got 7:31, but I think that should be 7:28.
Mr. Dodson, do you have a lawyer?
Got two.
You got two lawyers?
Flanagan and Mr. Spratt both.
It is.
They're gonna fight.
Both of you stand up over there by him.
They're better looking tie than me.
So, what do you represent this gentleman on?
Well, go ahead.
You first, Mr. Spratt.
Your Honor, I represent, Mr. Dodson on 13997 and 14049. I believe those are the same case with superseding indictment. And then I think 14971, which I believe is a DUI.
And they are set for, there's two set for trial on 7:31. My apologies. That's 14395 and 14396 are set for 7:31 for trial.
Mr. Flanagan, what do you represent him on?
Whatever numbers he didn't say.
I think those would also coincide with the same numbers that Madam Clerk just said.
All right, this is a misdemeanor driving under the influence of an intoxicant methamphetamine, or actually possessing a controlled substance, methamphetamine, driving while in possession of methamphetamine, and driving without proper lights, a light law violation. Do you intend to hire one of these two lawyers or a third lawyer to represent you? Pardon?
One of these two.
Okay, you got a coin you want to flip, or you want to just decide which one you want to represent?
Throw the indictment to the floor and we can violate.
You're closer to him.
Mister, do you want to at least arraign him?
All right. Waive formal reading, enter plea of not guilty.
We're not guilty as entered. We're going to show that Mr. Dodson is going to hire a lawyer. I don't care, seriously, I don't care who you hire, but obviously you're able to hire a lawyer. You've already hired two. So you just decide who you want to represent you, and whether it's one of these guys or somebody else, that's up to you. But you're capable of hiring a lawyer, so we're not going to appoint one. And we'll set it for status on when?
Can we put it on 7/14? See if we can.
July 14th. And then the rest of his cases are set for trial July 31st. So, all right.
Thank you, Judge. Thank you, Your Honor.
Docket number 15071, State versus Joel Robert Donovan. Mr. Wanick.
That's the one you may be aware of. Mr. Donovan had to go out of town unexpectedly. His mother passed away.
Oh, that's right. I did get an email about that. So do you want to put this on what, June 30th? When did you indicate you want to set it?
We did. We just needed to pick a
Needs
new
to be
trial date.
trial date. Your Honor, the victim's husband and Heeman was calling, and he was driving down here, so she stepped out, so we could second call it with her.
You want a second call it? Okay.
Please.
Let me do this. We've got lawyers who are sitting here. Let's just take them up one at a time, starting here with Mr. Baker. Do you have something I can take care of you?
I do. Mr. Wheatcroft, I think he's on the last page. Lost my DA, but I believe they were going to move to Nolly that case.
That was General McLeod, and I don't have any knowledge of that, so. Wait for her to get back in here and say yea or nay.
And Judge, on Mr. Leon, I believe he's set for a motion.
Wait a minute, Shane Wheatcroft. All right, so what are we doing with Mr. Wheatcroft?
Second call.
Second call, okay. All right,
And Judge, Mr. Lynn is on the docket today, I think, for this afternoon.
he's here, all right.
He's right here.
He's in jail.
Yeah, he's in custody.
He's
Can we
right
move it to 6:30, Judge? I got a global settlement on that this week. I'd like to talk to him. It may resolve the appeal issue and the other two pending cases.
All right, Mr. Lynn's case will be moved to June 30th. Let's try to see if we can resolve all of it.
Thank you.
All right. So that concludes you, Mr. Lynn, today. So,
Thank you, Judge.
is that all you have? Mr. Flanagan, do you have anything else you want to take up? Mr. McAvoy, you have something I can do for you?
Good morning.
Good morning.
I represent Richard Lindsay,
Last name?
L-I-N-D-S-E-Y, Lindsay.
Top of page 11.
Okay.
Judge, I talked to General McLeod, subject to the court's approval to the status date of 6th.
All right, so you want to go to October 6th for a status on it. October the 6th for Mr. Lindsay. Mr. Lindsay, stay in touch with your lawyer because that's the day that we're going to determine whether or not you're able to resolve it or going to have to set it for trial. Okay. You have a number of cases, so stay in touch with us. All right, thank you. October 6th, Mr. McAvoy, is that all you had?
Yes, sir.
All right, thank you. Mr. Waynick, do you have anything I can take up?
Not this time, Judge.
Oh, I'm sorry.
Good morning, Your Honor. Curtis Jones on page 9. I just need a plea date so that we can set an intake for the streets as part of this negotiated settlement.
Curtis Chance Jones, docket number 15043. And you're needing what now?
Just a plea date so that we can schedule the intake date as part of this.
Well, do you want to do it on June 30th? Next Tuesday?
General Cloud, that's fine.
Who's judging some?
Oh, you're back from maternity leave.
Yes.
So you're back.
I could only be so lucky.
Miss McLeod, I think you're prosecuting Curtis Chance Jones. Mr. Sergo needs a plea day to try to resolve it. I was suggesting June 30th.
Is July 7th available, Your Honor, at 9?
Not for me, but it may be.
Okay.
It's October 6th or this month, whichever day.
October 6th is available.
October 6th.
Thank you, sir. May I be excused?
You may.
Thank you, sir.
Judge, on page 8 is Daryl Hooper. Mr. Hooper is here, but he came in shorts, and so, but they're nice shorts.
Are you going
But
to
he's
represent
outside.
nice shorts or not?
Yeah.
You don't usually allow people to show up in shorts.
So
So
I'm gonna, you know, he's right over there. I'm gonna waive his.
he's on the other side of the wall. So
Yeah.
are you going to represent him on
I
that?
am. We're gonna waive reading of the
All
indictment.
right,
and
this
everything
is
tonight.
misdemeanor assault. So we'll
Yeah.
tell Mr. Flanagan is the attorney for Mr. Hooper. And
July 14th.
July 14th will be your next date. I am excluding myself from, or recusing myself from hearing this case since Mr. Hooper is a former divorce client of mine many years ago. So,
Judge, while I'm here,
yeah, you got something else I'm just trying to
I'm gonna try to help.
take care of as much as I can, as quickly as I can.
Who'd you say, Mike? Sorry.
Daryl Hooper.
They did. Oh, you checked.
July 14th. Judge, over on page 10, we've got Russell Kansas Klein. He is not back in town. We just need to try that case is older than some of the dogs I have. It's like a 10-year-old.
Russell Klein, docket number 13678 and 13707. So what do you want?
I guess we need another trial date.
Wait on the status of Civic 7.
We are.
So that could change that
It
case,
could.
hopefully to some extent. So y'all supposed to put on the 30th just to see if maybe I could reach out to the civil attorneys to see if.
Well,
they need-
as Mr. Flanagan pointed out, if they're very old cases, we need to try to either settle them or get them on the trial docket. So we'll put it on 6:30 for y'all to determine whether or not you're going to be able to resolve it.
Thank you, Judge. And then, yeah,
What else you have, Mr. Flanagan?
Judge, at the bottom of that page is Thomas Lane. He's in the Dickson County Jail.
Yes, and I did not transport him this time, because we transported him several times and didn't have anything.
He's also in that big conspiracy case. Whatever date we pick.
October.
We need to go after that.
The conspiracy case in Dickson County with the multiple defendants is the 19th through the 23rd of October.
Put on BOP day, I think.
Yeah. What date?
Is that after?
October the 27th.
Does that work?
Yes.
October 27th.
Miss Edie, if we can transport.
Yes, sir.
So as far as you know, Mr. Lane's going to trial on the 19th of October in that conspiracy case.
Yes.
Right.
Tried everything I can.
Did y'all rent the municipal auditorium for that?
No, I think it's.
Maybe trying to, depending on the weather, we might try it in the football field there at the high school or Creekwood High School. They don't know. I don't know, they whittled them down quite a bit. So only the recalcitrant, is that the right word? Recalcitrant lawyers are still stuck with having to try their cases. So.
Judge on page 19 is Jessica Wallace.
Jessica Wallace, last status. You need to set a trial date then?
All that. Put it on the 30th. Yes. Put it on June 30th.
So even though it says today is the last status, you want a really seriously last status.
That's just a suggestion.
For real.
June 30th. That will be the last final. Seriously. What else?
Judge, I got William Wilson on page 20. He's here. This is a case, I mean, the state's made an offer, and I hadn't really had a chance to talk to General McLeod about the facts of the case. No, I'm not gonna say you were on maternity leave. I couldn't get all of it. I think it's a close case between simple possession and possession of free sale, and I would like to talk to her.
I'm okay to either put in the 30th or October 6th.
Put it on the October date. He's got some other issues.
October 6th.
I think that's all for right now. Mr. Hammond, did you arrive?
He's outside the hallway.
So have him come into you.
You want me to just lay eyes on him since I've already ruled in his case?
So, can we get a date for Mr. Maddox?
What case is it?
Your Honor, on page 17, Jeff Staggs, good morning, by the way, Your Honor.
This is a case, we're gonna plead honestly, Judge, with this Demon case that was going. I just honestly have reached out to Mr. Maddox and then had a chance. We're trying to negotiate some numbers. We haven't settled. It's a theft accounting nightmare. We think we have it resolved. It was in front of Judge Turnbow. We can fit it in on this September 8th date.
September 8th.
Thank you, Your Honor.
Welcome. Is that all you have, Mr. Maddox?
Let's see.
Judge, Mr. Hammond's here. I'm gonna take him outside.
All right. All right, anybody over here got anything, Mr.
I
Spratt?
do, Your Honor, on page 6.
Page 6.
Yes, Your Honor, it's Deanna Graves. She filed a waiver and a request for discovery, and I just wait formal reading, enter, plea not guilty.
Plea not guilty is entered. The DUI case, first offense. What?
August.
I'm voting on Your Honor while she was on.
August 11th. Yeah.
August the 11th for status. All right.
Judge authorized to do status.
Well, it's just for status slash. plea.
Set for trial.
Yeah.
Oh. So y'all are aware.
And then, Your Honor, on, I'll take these up out of order. It's okay. For page 12 is Timothy Lori. Mr. Laurie has retained me. He is not present. He's on misdemeanor probation with Miss James downstairs. That being said, he has had an issue, substance-related, alcohol-related issue. He is enrolled in recovery. I'm reaching out to get a release, and I never got the waiver signed.
Try not to sneeze.
Good cows.
I'll use your report here as the blanket. So.
And we did receive that letter as well yesterday, so I think I made a note on the docket.
All right. We have a letter from the rehab that clerk has indicated that your client has entered a 30-day program. So what's the state's position?
Your discretion.
Let's try to get him some help. So you want to just set up, we'll show that Mr. Spratt is the attorney representing the defendant. We'll let him waive the formal reading of the indictment. Think about it.
We put that on July 14th.
July 14th will be the next court date. And obviously that won't be quite 30 days, but you can let the judge know at that point what the status is.
I'm reaching out to get him to sign some releases so I can get further info.
All right. What else?
Your Honor, on page 10, I have Bobby Kilburn.
All right. This was for us to review the mental evaluation. Has that been completed?
It is not, Your Honor. It's due to Ms. McLeod being out on.
Judge, I have nothing to do with his not getting his motion done.
No, that is, she's correct, Your Honor. I did not get it's an agreed order, a motion and an agreed order filed. I did not get those filed before she went out.
So what do we need to do?
If I could have one more status with 10-6.
So has there been an order entered for an
There is
evaluation?
not, Your Honor, and I'm literally going to finish drafting that today.
And if we're going to do an order for an evaluation, then we need to put it for the October date to allow that to happen.
Yes,
And I'm going to put it on, are you going to be here on the 30th?
Yes.
Then bring your order on the 30th so that me and so Ms. McLeod and I may both sign off on it and get it entered. Let's do it that way.
Do I need to have Mr. Kilburn present that day?
No, Mr. Kilburn just needs to be here on October the 6th. You just need, Mr. Kilburn, we're going to order an evaluation for you, and you need to cooperate with that evaluation. That's going to be a condition of your bond, but you have to cooperate with the evaluation that's being ordered. Your lawyers requested it. I'm going to agree to it and get you evaluated, but that means you've got to cooperate. So if you don't show up, don't do what you're supposed to do, then I'll consider that to be a violation of your bond condition. You understand that? Make sure that's noted on the file. All right, we'll see. Mr. Spratt's going to have the order for me to sign for that evaluation next Tuesday, okay? You're free to go until October, but stay in touch with Mr. Spratt.
And Judge, for the record, Mr. Kilburn has stayed in touch, and they've been trying. This one's just a statement. So.
What else?
And then finally, finally for me, on page 19, I have Mr. Wade. John Wade.
Wade, John P. Wade on page 19, docket number 15080.
Mr. Wade is present, Your Honor, and that is another. This, I think, was confusion before General McLeod left. There was some discovery that we had discussed. That being said, that discovery would probably change the dynamics of the case. So I spoke with her yesterday as to whether or not I'm going to request that discovery. But I need to talk to Mr. Wade about that. So I'm pleased with the objection to one more status on this case.
No, there's not, but and we talked about the CID, we discussed our policy. Those are released from going to practice.
We did yesterday. I didn't know that. So that's why I'm asking for those status.
It's been our policy since you practiced.
Everything's consistent.
This
Policies.
I'm okay with one more status, 10-6.
All right, October the 6th, that'll be the final status day.
Finally, Your Honor, for Mr. Odell on page 18, have a Mr. Travis, Tanya Travis. Your Honor, Mr. Odell was out of town. Spoken with him. I believe Ms. Travis, correct me if I'm wrong, was incarcerated somewhere else until the end of March. And so Mr. Odell was requesting a final status date to speak with her about the case. He's in Mexico. He was walking yesterday and breathing better than so I think he needs some exercise.
Yeah, Mr. Odom is in New Mexico. He told me as well. He asked for what the status is.
All right, when you want to put it,
10-6, that's fine.
October 6th.
That's all I have, Your Honor, if I may be excused.
Mr. Atchison.
I didn't step on any toes. So double checking. Judge, the last one I have is Mr. William Vick. He's also present.
William who?
William Vick, and that's going to be page 19 when you're on the docket. Judge, it's my understanding we just need a new date for Mr. Vick. We had him set for trial. Then we had a witness issue.
Right. So you need a new trial date. We had set a DUI in October, I think, on the 7th. Any reason we can't put this one on the same day, October 7th?
October 7th is fine, Judge. I already have a DUI set that day.
Anyway, October 7th.
10-7.
Understand we may start selecting the second jury when the first one goes out.
Sure.
It's quick, so.
Find something to occupy my time.
Right.
Thank you, Judge.
Good morning, Your Honor.
Good morning.
State versus Crystal Carter on page 3 of the document, Your Honor.
Judge, in this case, Mr. Carter had undergone a mental evaluation. The results came back. He is found competent. We have a transfer hearing scheduled for the same type of charges that are pending in juvenile court. That's scheduled for July 15th. Pending the outcome of that, I may or may not need to amend my indictment. So I would ask you to give us more status date of 10-6.
Right. Any opposition to that?
No, Your Honor, I'm just checking there.
October 6th.
Thank you, Your Honor.
Mr. Sanders.
Motion for new trial on the docket, State versus Corey McConaughey. Spoke to Ms. Edie yesterday about getting a Zoom link for today, and she advised me that that was on. And my oversight, I just didn't realize that it was on the docket today. I thought it was next month. So I'd like to get a new date for that motion, please, for
Tomorrow.
preferably not.
Thursday.
Oh, hey, Judge, my only question would be, I assume you wanted to see my file.
I think he had called me about a Zoom link for himself, and I mentioned to him that he had this on here as well, and he came down because
But there was no, Mr. McConaughey wasn't here anyway.
I can't because I didn't
Oh,
want to
okay.
break the state,
sorry.
and I would have done the same for Lynn had I known not to bring him too.
I don't know if we could do the 30th, Judge. I know it's getting pretty full maybe, but. Well, it doesn't matter to me, Judge. He's incarcerated, whatever you call
I'm
it.
leaving to go out of town tomorrow. I'll be back. Whatever y'all said, so we're back to October. I mean, it's fine. It's whatever the court wants to do.
7 is your BOT day in October.
All right, we'll put it on October the 27th.
Thank you, Judge.
Take a recess. We'll be in recess for about 10 minutes. So.
All right.
Mr. Flanagan,
Page 8, bottom of the page, I missed it earlier. Andrew James for arraignment. Lay formal arraignment, enter plea of not guilty.
all right, plea of not guilty is entered.
Be that August date.
August the 8th.
August the 11th is docket called.
August the 11th.
August 11th. Judge Aiden Allen, which was at the very top, we're gonna need a trial date on that. That's the voting under the.
Judge, I think we said 1 or 2 on the 8th. So-
October the 8th, we've got 2 DUIs. I just am reluctant to set any more, but what about October October the 7th, we've got 2 DUIs now, right?
Yes.
So do you want to set this one on the 8th?
That's what I was gonna say, Judge, if that's okay.
It's fine with me.
Didn't we put Danforth on there?
You would-
That would be the first.
Yeah, that was just 2 days, but
And then
You just want to put this as a backup or whatever you want.
or we'd go with 28th or 29th.
What I don't want to do is to set several on the same day that we know we're going to have to go to trial. We did set Mr. Dainsworth on the 8th. What were you saying?
I was gonna say, Judge, maybe we should go to the 28th or 29th. I'm good with either day.
All right, how about the 28th?
Judge, I've got the vehicle homicide. Either Cheatham or Dickson.
And is that going to go 2 days?
Well, John Stevens, yeah, it'll go 2 days.
Well, let's just put it on the 8th, backing up to Dainsworth. We can put 2 on one. All right, so this case will be set for trial on October the 8th.
Judge, I think the only one left is Mr. Ferris, and he's here. We're gonna
do that to July the 14th.
July the 14th.
Last name is what?
Ferris.
Top of page 15, Judge.
All right, Ferris. And we are going to set it for July 14th. All right.
I think that's right.
Can we go back? I had that marked as status. I'm sorry. That should have been an arraignment. That's a new arraignment. That's my fault.
Mr. Ferris.
So, yes.
Oh, it
here
is.
His,
Here you go.
We wait for him, Raymond, interplay is not good. That's okay.
Says if we go back to Mr. Wheatcroft, that's the one I believe the state was going to nolly.
Yes, Judge, I spoke to the victim on this case, and she does not want to pursue charges. Made that really clear to me. So I'm going to nolly that.
On page 19, Shane Wheatcroft. And so it's going to be a dismissal.
Yes, Judge.
All right.
Thanks.
Nolly by the state.
Judge Trent Short, 15188, Short's here. Well, we said 10-8, sounds like 10-8 is full for trial.
The DUI, so we've got
I'm sorry, sir. What was the name?
Short, Trent Lee Short.
You have another date besides 10-8?
All I have to do is
I do 29. Does that work?
29th,
29?
October 29th.
That's right.
Okay, I went wrong. All right. The next case is Mr. Anthony Smith, 15189. And we can, after speaking to general, we can set that on 10-6 for status.
October 6th.
Yes, please. Mr. Smith. And then we have Mr. Joel Donovan's next.
Judge, this case is probably going to take about 2 days at least to try. So we really see if your honor had any more than February dates, you might forgive us.
We like them February dates.
Joel Donovan, aggravated sexual battery.
Yes, Judge.
And we were talking about February. February 24th or 25th. 2 days.
Yes, Judge.
So those days work.
Yes, Judge. Then we have another one being drug screened. I'll wait till that's back.
We brought to over Shonda Lombardo.
Oh, yes, Judge. It's my hope that we were going to be able to enter an agreement today, but I believe the state's going to need to do an information in order to effectuate our agreement, which we have reached. So if we could roll that to 6:30.
Right, June 30th for Miss Lombardo. Right, we'll put it on June 30th.
Thank you, Judge.
Motion to revoke is set that date.
Yeah, it's already set that day.
Okay. Marvin Northington,
You got an agreement on that one?
page 14.
Tendering for a plea petition by which Mr. Northington will be entering a plea of no contest in 15153, in which he'll plead no contest to count 2, possession of unlawful drug paraphernalia, for which he will receive a sentence of 9 months to serve, concurrent to any other sentences that he's currently serving. I believe he's serving a Dickson County sentence or sentences. He would be assessed $150 fine plus court costs, and counts 1 and 3 would be dismissed in settlement. He would be eligible for 75% release eligibility. He would also receive pretrial jail credits from January 28th to 25, and then March 11th to 26th until present.
Oh, Mr. Northington, I'm not going to ask you to raise your right hand because I know you're limited, but do you understand? I'm going to ask you to take an oath to testify truthfully.
You solemnly swear or affirm that the testimony you shall now give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you.
Step up to that microphone so we can pick up everything that you're saying. We're recording everything that we're talking about, okay? State your full name for the record. Mr. Northington, you're here today on a 3-count indictment. You've heard your lawyer talk about what the agreement is on 1 count and 2 of the counts are being dismissed. But do you understand that you have a right of what you're charged with and what possible defenses you might have? And if you talk this over with Mr. Sensing, feel like you fully understand everything?
Yes.
Well, it's indicated you want to enter a plea of no contest or nolo contendere. That's the same term. What that means is you're not going to admit you did anything wrong, but you're not going to contest the state's evidence, and they're going to tell me what their evidence will be at trial, and I'll use that evidence to find you guilty according to this agreement. Do you understand that? Yes. You understand, however, that you can plead not guilty and have a speedy and public trial by jury in this court.
Yes.
You understand if we had the trial, you would have the right to have an attorney and have one appointed if you cannot afford, and we've done that with the public defenders.
Yes.
You understand that if you went to trial, you would be presumed to be innocent until such time as ever the state proves your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted. You understand that if you went to trial, you would have the right to confront and cross-examine every witness the state called to testify against you, and you would have the right through your lawyer to bring in additional witnesses on your own behalf by using a subpoena. You understand you'd be presumed to be innocent. You would not have to testify or prove anything at trial, and no inference of guilt would arise because you did not testify at your own trial. You understand if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes.
You understand that by pleading no contest, you're waiving your right to a trial and to an appeal, and all I'm going to do is approve what your lawyers worked out.
Yes.
But you understand that's going to result in a misdemeanor conviction that will be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime.
Yes.
You understand everything I've explained to you. You want to plead no contest according to this agreement and waive your right to a trial.
Yes.
Is your decision to plead no contest today voluntary?
Yes.
Anybody forcing you to do this against your will? You understand I cannot accept your plea unless I'm satisfied there's a factual basis for it and that you are in fact guilty of this charge.
Yes.
And listen, as the state tells me what their evidence would be if this case went to trial. You'll step to one side and let the state come up and have the microphone.
Yes, Judge, if this case had gone to trial, the state would expect to be able to show that back on January 28th of 2025, Officer Adam Curtis with the New Johnsonville Police Department made contact with Mr. Northington here in Humphreys County. He noticed him speeding, so he turned around and stopped him. And when he made contact with him, he was advised that he had an active warrant out of Houston County. While he was arresting him in a search incident to arrest, he found a glass pipe, and Mr. Northington admitted that that was a crack pipe and that it was his.
I'm not asking that you agree with those facts, Mr. Northington, but do you understand that's what the state's evidence would be if you went to trial?
Yes.
You still wish to plead no contest?
Yes.
Are you satisfied with your attorney's services?
Yes.
You feel like Mr. Sensing's done a good job representing you confidently?
Yes.
Mr. Sensing, you know of any reason you should not enter this plea?
I do not.
Then Marvin Northington in docket number 15153, upon your plea of no contest to count 2, I find you guilty, sentence you to 9 months in the Humphreys County Jail. That sentence will be served concurrently with all of your other sentences, and you're ordered to pay a $150 fine and court costs, and you counts 1 and 3 are dismissed as a part of the agreement, and you have pre-sentence jail credits as set forth on this document. Okay. All right. Thank you. We have one more inmate.
Yes, sir. Jennifer Smith.
We have Miss Lowe. Have we heard from Miss Stephanie Lowe? Anybody heard from Miss Lowe?
Oh, Your Honor, we're gonna pass that. Ms. Lowe, I think there was some confusion about the motion. We're glad to talk here. We agreed to move it to June the 30th. She does have a hearing in Houston County on the morning of the 30th. I think she can be here lunchtime-ish. So I told her we'd set it in and we'll address it if she can't be here.
All right, June 30th. Ms. Smith, your lawyer will be here then. Thank you.
I think she does have a new arraignment on that 15275B is a new arraignment.
Let's just do the arraignment on that 30th
Okay.
as well. You are right. All right. Anybody have anything else before I go back to trying to call the doctor again?
I do have 2 of the affidavit of indigencies.
Let's try to get
Okay.
through it one
Yes,
time
sir.
and then I'll come back. Looking at page 8, 15176, State versus Rachel Beth Hassel, public defender.
Yes, sir.
Judge, could we reset that to the October status date? I'm still working on getting some medical records together.
State okay with that, October 6th? All right, October 6th. Thank you. Docket number 15177, State versus Jason M. Hensley. Mr. Hensley, today was the day you were to advise us as to who you've hired as a lawyer.
I didn't get one. I just represented myself.
You're going to represent yourself? Okay. Have every right to do that. You read through the rules of criminal procedure, correct?
Mm-hmm.
Have you read through the rules of criminal rules of evidence?
Mm-hmm.
Okay. You understand those are going to apply to your case?
Yes, sir.
And this is a Class A misdemeanor stalking charge.
Yes, sir.
All right. State want to set a status date since he is representing himself.
Yes, Judge, 10-6 is correct.
We're going to put it on October the 6th. I can't give you legal advice, but I would suggest you might want to make contact with the district attorney and try to talk with them about your case to see whether or not there's any way to resolve it by some sort of an agreement. Other than that, we'll set you a new, if you don't resolve it on October the 6th, I'm going to set you a trial date.
Okay.
Once I set you a trial date, then you're going to either go to trial or have to plead to the indictment and let me go to sentencing with you. Okay. So if you want some sort of agreement worked out, it's up to you to contact the state and see what they'll offer.
All right.
All right. On page 9, State versus Billy W. Jameson, docket number 15268A.
He's in jail, Judge, and they set him for
Oh, I did put it on
714.
there. Can't look at my own writing. 15118, State versus James J. Jessel, public defender.
Yes, Judge. Jessel is approaching the lectern. Could we reset that to June 30th? I think we're close to reaching an agreement.
All right, June 30th.
Yes, Judge.
All right, thank you. We did Curtis Chance. Looks like on page 10, State versus Ryan Andrew Lancaster.
That's fine as well, Judge, except for our restitution payments review. Mr. Lancaster's appearing via Zoom. My understanding, Judge, is that he's making payments as agreed or as ordered.
The only one I know is this, yesterday he tried to call, he was only gonna pay $300, and I think he's supposed to pay $750. And his card would not go through. I did advise my bookkeeper to let him know if it did not go through, he needed to be here today. And so I'm assuming he called back and made his payment and it went through.
I believe, and I don't have it, I think he told me that he had made that payment. Mr. Lancaster, were you able to make that payment?
Yes, I was able to make the payment yesterday for $300. And as we discussed, I had had some financial hardship this month, and I plan on making another payment just as soon as possible to get myself back on schedule.
Yes, sir, he has.
All right, well, if he's been making some, but you just had a problem with this one, then I don't have a problem with continuing to just set it for status.
That's fine, Judge, but my understanding is he's only paid like maybe 2 payments, if I'm not mistaken. So I would ask that he be required to submit some proof of employment to the court with his income so we can have a look.
So what are you asking me exactly?
If he be ordered to provide proof of income and employment, things of that nature, so we can make sure that he is making money that's supposed to be, or he said he would be making.
So I think that he's been making payments since March. So I guess that would be, 3 or 4 payments. But I mean, I can get him to get me his pay stub if that's what you want me to do.
Mr. Lancaster, I'm going to order that you provide to your attorney proof of your current income so that we can make sure that you have the ability to make the payments that we've been ordered. So, but the order of $750 a month remains in full force and effect, and we'll review it on October the 6th. Actually, let's do that October 27th.
Yes.
October 27th.
Yes.
That's the VOP day. So make sure you make those payments.
Thank you, Judge.
Looks like we're next going to the William Richard McCardle and docket number 14572, page 13.
Payment review, it looks like he has made some payments. So I would just suggest we reset it to allow him to keep making payments.
Reset it to when?
Just whenever your honor says, just to make sure he keeps making payments. Since he's kind of been on this VOP status, we've gotten something, but there's a general house case, but it's a pretty big.
We're going to keep monitoring your payments to make sure you keep making them, and we'll put you on October the 27th for another review.
Yes, sir.
Right.
May I have that written?
And you got something to write down for you.
October 7th, check.
October 27th.
Thank you.
Thank you.
Can I make an announcement?
Yes.
Casey Traxler, it may be in there as Newman Traxler, I'm not sure. 15186. Mr. Traxler is present. He is currently in recovery. He was drug screened just a few moments ago, and according to the bailiff, he passed his drug screen. Spoke to the general, can we set this for status of 10-6?
October the 6th.
Yes, sir.
All right. October 6th it is. Item 14801 State versus Dylan Scott Neely, and we reset all of Mr. Patrick's cases for June 30th. Is that correct?
Yes. Mr. Neely's here.
You, Dylan Scott Neely. Mr. Patrick, your lawyer is has had a medical emergency, and so we've moved all of his cases, including yours, to next week, June 30th.
Yes, sir.
All right, thank you. 14294A, State versus Timothy James Osgood. Osgood, I'm advised that you have been successful on your community corrections. If I'm understanding correctly. Is that right?
Yes, sir.
And that they're now wanting to, because you've been successful in that stage, they're asking to transfer you to regular probation. So I'm happy to do that for you. Understand that while you've done well and you've completed the community corrections portion, you still have regular probation for the remainder of your sentence. So make sure you keep on the good side, okay? Good luck to you.
Thank you.
Judge, if I may.
Do you know who his probation officer is?
Mr. James. We don't know yet. He's gonna be transferred to Erie County.
Oh, okay.
So Mr. Osgood does work out of state, currently in Alabama. We've been doing travel passes for him. Corrections. I think it would be a while before he could get past state probation, just until he gets his new officer in fiscal intake. Wanted to see if the court would allow us to put a order that would allow him to travel by state for work purposes.
What do you do for a living?
Fire protection.
Fire protection?
Fire protection, working in, maybe in Alabama.
I don't have a problem with that. If you supervise him, you tell me if you think he's a risk to run off.
I think he would do fine. He's been getting passes for 2 weeks at a time and he hasn't had any problems.
I'm going to allow you to do that, but don't you go RUNDOST, okay? So we'll authorize that.
Thank you, Judge.
Next one is 15027A, State versus Jeffries, Stephen Penix. That's Mr. Patrick's case. And Mr. Penix, your lawyers had a medical emergency. We're moving his cases to next Tuesday, the 30th. We'll see you then. 15158B, State versus Cassie M. Plunkett. Thunder.
Yes, Judge, there's a co-defendant in this case that Mr. Soul represents, Zachary Smith. Judge, it's set today for stat and both parties are approaching the lectern. This was set today for status as well as on my motion to dismiss counts 1 through 6, I believe, as well as my motion to sever. Based upon what was going on this week in terms of that trial that's got continued, I agreed with General McLeod to move all of that to 6:30. However, I understand Mr. Saul is not available on that date.
Judge, I'm sorry, I've got other matters in Davidson County that day.
Is it possible to hear these motions later this week since the trial got continued? I don't know what witnesses you need to line up or if it's just legal argument. But
I probably wouldn't be witness, just me researching case law.
And I think that we may be able to reach it. I mean, it seems like we're heading in the direction of reaching some sort of agreement.
It depends on what Cincy deems reasonable. But I'm okay with if we could hear maybe Friday. Okay with that? I have course on Thursday here. Doesn't matter. Got Thursday.
I mean, we have sessions, but I could cover sessions of Thursday, Friday.
sure, I'd rather do Thursday than Friday, but
That's why I mentioned that.
I can be here Thursday.
I'm just thinking court.
Mr. Saul says he can be here Thursday. All right, let's just set all your motions in for Thursday, okay?
Yes, sir.
Yes, Judge.
Thank you.
Do I need to do an amended notice of hearing?
Oh,
or
no, please.
anything?
I am ordering that all of them be set for Thursday, and so that'll take care of it.
Thank you. Judge.
One 15029 State versus Susan R. Scammell. Scammell, you are here today to be arraigned on a charge of violation of probation. You have the right to an attorney. Do you wish to have a lawyer? This is actually here for payment of cost, and it's indicated you need to have your probation extended for you to be able to pay the court costs and fines.
I have no job. I've gotten a few jobs, but at my age, I can't do what I used to do. So I'm trying to, I used to clean, but they let me go before because I'm not fast enough anymore to do it. So I am actively looking for a job. I do good to get the probation fee together for the probation. So I live with someone, he lets me live it, and I get food stamps. So I like to say is I'm actively looking for a job that my body can handle. So
raise your right hand.
You solemnly swear or affirm that the testimony I give shall be the truth, whole truth, and nothing but the truth, so help you God.
Yes, I do.
So are you working anywhere?
No, not right now. No.
And I'm not going to ask you your age, but obviously you're not just graduated from high school. But
No.
is that a factor in being able to find employment?
It is.
When you have worked, is it just the cleaning houses or what is it?
I worked hotels lately before, but I used to clean houses. That's what I did all my life: commercial buildings, houses, hotels for companies.
May I ask her probation officer, has she had any other problems?
She hasn't, Your Honor. She hasn't. She just needed some more time.
I'm going to remit your fines and costs, and her probation would be over if that is the case. Is that correct?
With Your Honor.
I'm going to remit your fines, costs, and probation fees, meaning that because of your failure, your inability to make payments because you have no income, we're going to give you a break. Since you've done well on probation, I don't like, our Constitution prohibits in jailing people for debts that they owe. It's one of the things that our forefathers found most offensive about the British rules is that they could put you in debtor's prison. So our Constitution prevents us from incarcerating people solely because they owe money. Fines and court costs are a little different, and it can be a basis for revocation of your suspended sentence. But based on the fact that you've done well for the last year and not had any problems, and it's just a purely economic situation, I'm going to give you a break and tell you that we're just going to wipe the slate clean and get you off for probation. Now, if I see you in here again, I'm going to know that you took advantage of that and didn't listen to what I have to say, so make sure you don't have any other problems, okay?
Thank you, Mr. James.
Her fines and costs are just are remitted. I'm dismissing this probation warrant as well.
Thank you.
Had you had problems on probation, I wouldn't be doing this. Okay?
Thank you, sir.
All right, thank you. Looks like, let's see, Jennifer Smith removes her, right?
Yes, sir.
Looks like the next one would be on page 17, Marissa Dawn Smith.
Judge, she's
That's
codependent. We reset her to 10-6, whereas the Andersons on page 1.
And we're putting on what?
10-6.
10-6.
Yes, sir.
All right. And Mr. Snook is Mr. Saul's case, and that's set for this Thursday.
Yes, sir.
All right, we'll look at page 15 and page 18. Spencer Stanfield was Mr. Flanagan's case. And
June 30th.
June 30th.
Yes.
Okay. We'll write that down. 15194 State versus Robert Gregory Unger. Public defender.
Yes, Judge. I represent Mr. Unger. He's currently in federal custody facing an indictment based on the same facts as state indictment is. Here, can we reset this to October the 6th?
October the 6th. Thank you. Moving to page 20, 15278 State versus Leonard Wheeler. And there's J.P. Bradley that filed a waiver and surrender.
Yes, sir.
The attorney will be J.P. Bradley.
July 14th.
July 14th will be the status date. 14960 State versus Bobby Daniel White.
That's what we just tried last week, Judge.
Pardon?
That's what we just tried last week.
Oh, we did try it last
That
week.
was set for 6.
We've set the sentencing hearing down the road as well, right?
October, I believe, October 6th. I've got the pre-sentence report order for you to sign.
15081 State versus Jane M. Willis.
Judge, that's set for a status today as well. Ms. Willis is approaching the podium. Judge, can we get this reset to October? And I'll tell you, I know it's been set for a few statuses. It's just turning out to be a relatively complex case. And I'm still awaiting certain evidence, reports that would be necessary in order to have a fulsome settlement negotiation. And I don't believe I'm going to get that until at least July, despite my best efforts. So, it's just a bunch of scheduling problems.
They'd have any problems with the October date? October the 6th.
Thank you, Judge.
That'll probably be Mr. Sensing the final status date. So,
Thank you, Judge.
and Mr. Wilson, is there anyone in the courtroom who understood you had a case today that your name has not been called? Not the second call, but you've not been called at all, come to the podium, please. If you have a case that you have not been called, come up to the podium. What is your name?
Robin Haskins.
Bobby.
Robin Haskins. Mr. Patrick's my attorney. That's the codefendant with Mr. Penix. And that was reset for June the 30th.
Your case got, and who's your lawyer?
Mr. Patrick.
Oh, Michael Patrick is your lawyer.
Yes, sir.
He's had a medical emergency, so we've moved all of his cases to the 30th. That's next Tuesday. So you're free to go until then.
Okay. Thank you.
No, we have a second call from the. Mr. Lockhart, you have a motion to be heard in your case, is that right?
Also, a motion to revoke bond, states file.
All right, so let me take up these first. Arian Deborah Byrne. Ms. Byrne, you've submitted an affidavit. Is all of the information on that affidavit true and correct?
Yes, yes, sir.
I find that Ms. Byrne is indigent and therefore will appoint the public defender to represent her. Plea of not guilty is entered. Status date,
July 14th, Judge.
July 14th, Ms. Byrne. Stay in touch with your lawyer, okay?
Hey, Judge, I want to make the court aware that on the motion to revoke bond, I've asked the deputy to be here at 1 o'clock. Do I need to simply be here now or when you're on a break?
1 o'clock will be fine.
Thank you, Judge.
Mr. Lockhart, we're gonna have your hearing on the motion to revoke bond at 1 o'clock.
Yes, sir.
Nina Karen. Karen, you've also submitted an affidavit, and is that information true and correct?
Yes, the phone number is at 615.
Don't give your phone number out, but just, let me just ask this question. You don't have any income at all?
No, I don't.
Okay. How do you live if you don't have any income?
I have a hard time.
All right, I find that she is indigent, so I'll appoint the public defender to represent her.
Wait, one ran the diamond enter, please not guilty.
Who's not guilty is entered.
July 14th, Judge.
July 14th is the next status.
One more, Lisa, I don't have the form, that's indictment, I believe she's got a form with her.
Lisa Culp. You'll hand your affidavit to Officer Bill. So you receive Social Security disability, and that's your only source of income. And all of this information, is that also true and correct? And I'll report the public defender to represent this Colt.
Wait for ran the diamond enter, please not guilty, Your Honor.
So you're not guilty is entered status, July 14th. What is Mr. Clarence, Mr. Roberts?
Or John Blue. Because I see on page 6, I don't have anything written by Christopher Dunn. And maybe I just missed it.
No, you didn't. 15261 State versus Christopher Wayne Dunn. For arraignment.
At large.
Mr. Dunn is at large.
Oh, we haven't picked up yet.
No, I don't have anything, I don't have a return on it.
Does that mean oh,
Yes.
I didn't remember.
All right. Then all we have left on our docket for today will be the State versus John Isaac Brewer, and that's a motion to revoke bond. Is that correct?
Thanks, so just on the, just to confirm, did you try to do anything on Hall, or are we going with 6?
Said I was going to check, and I didn't.
That's all right.
I have a few minutes before lunch, so I'll call.
Hey, we got no problem, Judge. I'll be here. Sure.
All right. Let me go ahead. We'll break for lunch until 1 o'clock, and I will check with them about the schedule in August for Mr. Hall. And we'll stand in recess until lunch.
All right.
1 o'clock.
Is it a break?
All right, so what we have left is
Brewer with Jake Locker.
Jake's here.
so I need to see that file.
Jake went to find his spot, I believe.
The motions, this file. And like I said, he does have one where he had a status he did not show up on. And so he's got a case to hold for him. And they probably need to pick him up on unless she knew all that. And that is in this file.
I wish he was.
Let me see, see council. Ms. Locker.
She did something.
Well, next time, just get her to touch it.
She opened the door.
No,
That's the craziest.
that's my knowledge.
I guess I remember something. Too big. It won't be too big though. It's too big. I can't take care of it. You'll let it go, trust me. I'll get that finished, I promise you. But I try to put them into
Well, that wasn't my job.
I know.
All right, this is the state of Tennessee versus John Isaac Brewer, docket number 15035, and that is the state's motion for to be bond that is involved. State ready?
Yes, Judge.
Mr. Locker, I know your client's not here, but we set it at 1 o'clock, so we're ready to proceed.
Yes, Your Honor.
State may call your first witness.
Well, Your Honor. Your Honor, the state moved to ask that Your Honor just revoke his bond from the bench since he's not here. He's supposed to be here in court today. He already has a pending case prepared to appear with no hold.
State is moving for the court to revoke his bond because he is not here for his 1 o'clock hearing. So, any response?
No, Your Honor.
Right, it'll be a conditional forfeiture of his bond. KP is issued for his defense for his arrest. There'll be a hold for hearing. We'll have a bond hearing if necessary, but
Thank you, Judge.
send a citation to the bonding company and set it for 6 months down the road, whatever the date will be.
Judge, you said my motion will be reserved for hearing at a later date if necessary. Is that okay?
You can reserve your motion pending his arrest, and if he makes a motion to reinstate his bond, then we'll have a hearing on it at that time.
Thank
you. Well, short but sweet.
Thank you, Judge.
Court is adjourned.
Judge, we don't I don't have an answer from General Crouch yet on August 6th or 7th. So if you give me a little bit, I'll reach out to you.
I will be here Thursday. So.
Yes, sir.
Thursday, you'll be, okay, well, I'll get an answer by then.
I will too. He's here.
All right.
Not so short, not so short.
Judge, can I get some signatures from you? I'm the only vulture you have to deal with today. So warrant for it when you go.
Just whether this information is true and correct.
Yes, sir.
So you want this person held? You want this person held?
Oh, yes.
Let me get the rest of them after I do this.
Yes, sir.
But we are here for the motion to revoke bond in State versus John Isaac Brewer. I had previously made a conditional forfeiture of his bond for his failure to appear at 1 o'clock, and he's coming to the courtroom, so I'll set that aside. We will now proceed with your motion to revoke bond.
Thank you.
You may call your first witness.
Your Honor, the state will call Deputy Logan Stewart to the stand.
If you'll come forward, please. Ask you to raise your right hand and let the clerk place you under oath.
You solemnly swear or affirm that the testimony I give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, ma'am, I do.
Take a seat, please.
Deputy, can you state your full name for me, please?
Yes, ma'am. Sergeant Logan Stewart.
I'm sorry, Sergeant.
Okay.
And where are you currently employed?
Humphreys County Sheriff's Office.
And were you working for them back September 26th of 2025?
I was, yes, ma'am.
And can you tell the court how you came into contact with Mr. Brewer on that date?
Yes, ma'am. The reason for the contact was actually a traffic stop initiated for improper display of registration. He didn't have any tag lights eliminating the rear registration plate on the vehicle. So I conducted the traffic stop. He was the driver and sole occupant of that vehicle.
Okay. And was that stop conducted here in Humphreys County?
Yes, ma'am.
Do you remember whereabouts?
Yes, it was actually 13 South in front of Speedway and in front of Barnett's as well.
All right. And what did you notice when you approached the window to speak with Mr. Brewer?
Just immediately a defensive demeanor on the reasoning for my stop. And when I requested his vehicle documentation, first and foremost, I observed a shotgun lying on the front passenger seat. And when he was gathering his information, he kept reaching near it for an extended period of time. So at that point, I felt like for safety reasons, it was best to distance him from the firearm. So I requested him to exit the vehicle. He was very hesitant to do that. I actually refused multiple times, wouldn't open the door, wouldn't get out. I actually had to open the door myself. And then when I did open the door, he stepped out. I saw he had a knife on his person as well, that his hands immediately went down toward. Just a continued defensive demeanor.
Did you try to disarm him with?
That was the goal. Yes, ma'am. That was the goal. So I told him to put his hands on the truck bed, continued to be belligerent, kept trying to turn back toward me. So I felt like at that point in time, the best thing was to detain him and disarm him and just kind of secure the whole situation.
Was anybody with you on the stop?
Yes, ma'am. Deputy Benjamin.
Does he also work with Humphreys County Sheriff's Office?
He does, yes, ma'am.
Okay. And when you attempted, you said you were going to put him in cuffs?
Yeah, I was going to detain him, disarm him, and just secure the situation, put him in my patrol vehicle, secure the weapons. And as soon as I went to do that, he refused to place his hands behind his back, tried to grab onto the truck bed, just tense up, wouldn't let me get control of his arms. I was fixing to take him to the ground just to get a position of advantage and maintain control. And he just continued forcefully pulling on the truck bed with one arm, and then he started pulling my partner by his outer carrier with his other arm.
When you say outer carrier, what are you referring to?
It's his vest, and he was actually grabbing it at the top neck portion, pulling him toward him.
So he pulled Deputy Benjamin toward him?
Yes, into his body multiple times.
Okay. And was he eventually taken to the ground?
He was taken to the ground. The struggle actually continued. He struck me in the head twice, knocking my glasses and my hat off. Deputy Benjamin deployed a taser. This gained compliance after a moment or so, or after the initial, I think it was 2 cycles. And it did a good enough job to gain compliance to where we could get him in handcuffs, and that was it.
Does Mr. Brewer have a prior felony conviction?
Yeah, he's got a prior vandalism over 1,000 conviction. So what I can recall is criminal history.
And then you charged him with possession of a firearm by a convicted felon?
Yes, ma'am.
And then did you charge him with 2 counts of assault on a first responder?
I did, yes, ma'am.
And what is that for? Yeah.
So the first one is the grabbing my partner by his carrier, pulling him toward him forcefully. And then obviously the next one was striking me on the head multiple times.
And you also charged him with resisting arrest, correct?
I did, yes, ma'am.
Okay. And are you aware that Mr. Burt also has a current pending case in circuit court?
Yes, ma'am.
And that's prior to this incident, correct?
So the DUI? Yes, ma'am.
All right, no further questions.
Mr. Lockhart, do you have questions?
You're confident he has a prior felony conviction?
Yes, sir.
That's all the questions.
Any redirect?
How do you know he has a prior felony conviction?
Oh, I actually, ran a criminal history on that.
All right, no further questions, Judge.
All right, thank you, sir. You may step down. You may call your next witness.
I have no other witnesses.
State has rested their proof, Mr. Lockhart, on this motion. Do you have any proof you wish to offer?
Call my client.
Bruce, will come up, please. Raise your right hand and be placed under oath.
You solemnly swear or affirm that the testimony you may give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you.
If you would state your full name to the court.
John Isaac Brewer.
And do you recall the date you were arrested?
Yes, sir.
And it's what the officer testified to as to your behavior, reaching for a gun and those type of things. Is that correct?
None of that's true. I told him that there was a shotgun in the passenger seat as soon as he walked up. I'm like, I'm just letting you know there's a shotgun in the passenger seat.
All
By no means was I trying to reach for a gun.
That's all the questions I have.
And I don't have any felony charges, by the way.
Mr. McLeod?
So, Mr. Brewer, are you admitting there was a firearm in the vehicle?
Yes, ma'am.
And you say you have no felony convictions on your record?
No, ma'am. No.
You heard Sergeant testify, correct?
Yes.
Did he say you reached near the gun, or did he say you reached for the gun?
He asked for proof of my insurance, and I looked at my console, and I drive a Ford Ranger, so I'm like, well, maybe it's in the glove box. And I asked him, I said, you want me to look in the glove box? And I'm thinking the whole time if he would run my tags, it would have told him I had insurance. So when I went to open the glove box, he reached through the door handle on my truck's broke off, so the window was always cracked like this far. He never asked me to get out. He reached in the window and just jerked the door open and drove me out of the truck and started trying to get me on the ground. I didn't know what was going on because he grabbed me from behind. So I had no idea really what was going on. I wasn't trying to hurt anybody, honestly. I didn't really know what was going on. When they shot me in the chest with a taser, that about killed me, honestly.
You said you weren't trying to hurt anybody. What do you mean by that?
I didn't know what was going on. He grabbed me from behind and it was just like, I really didn't know what was going on. I never hit him.
So you're saying the sergeant's lying when he says you punched him in the head?
I didn't never punch nobody in the head. He said he broke his glasses. I'm thinking it's whenever he hit the ground. He got behind me and he did take me to the ground, but I'm thinking that he's, when I fell on him, it's probably what broke his glasses.
Why did he take you to the ground?
I don't know. That's what I'm saying. I wasn't trying to be, I would have dealt with him, done anything they asked. The only thing I can say is when he told me to open the glove box, there was a black Velcro wrist brace in there. He might have seen that and thought it was something, but I mean, I'm not saying that.
Is it possible you could have hit him?
No, ma'am.
You weren't fighting with him at all?
No, ma'am.
You weren't resisting arrest.
No, I didn't really know what was going on. When in a situation like that, like the way he grabbed me from behind, when I told him, I was like, I'm gonna reach over and look in the glove box. And, you know, he just snatched my door open and grabbed me from behind. I really didn't know what was happening. And
You didn't react to that?
I mean, I was trying to maybe get him off of me. I mean, I didn't really know what was happening.
So you were fighting?
Not really. I mean, I really didn't know.
Well, how were you trying to get him off of?
I really didn't know what was going on. I mean, they just attacked me for no reason.
Well, what did you do when they attacked you?
I mean, I really didn't know what was happening, honestly.
Well, you said that. I'm just asking you, what did you do physically? How did you respond?
I mean, I was trying to push him off of me, is what I was trying to do. I didn't know.
You were trying to push him off of you?
Yeah, but I didn't hit anybody.
Okay. You tried to push both of them?
No, ma'am. He was behind me. I never touched him.
You said he, who are you referring to?
Stewart, he was behind me.
Okay. No further questions, Judge.
Can you redirect, Mr. Lockhart?
No, Your Honor.
Thank you, sir. You may step down. You have any other witnesses?
No, Your Honor.
State, have any rebuttal proof?
Just, could you give me just a minute?
I will.
Nothing further, Judge.
I'll hear you an argument.
Judge, it's the state's position that the bond of the defendant should be revoked due to the fact that he was on bond for a prior charge of DUI in violation of implied consent. That occurred on June 10th of 2024. That case is still pending before this court. While out on bond, Mr. Brewer then got these new charges that occurred on September 26th of 2025 through Humphreys County. I know the court has the discretion as to whether to revoke the bond or to increase the bond, but the state would ask that based on those facts, and also, Your Honor, the defendant apparently did fail to show a report back in April for arraignment on these new charges. If I'm not mistaken, I was out at that time, but I believe that's correct. So Your Honor, I would ask Your Honor to take those things into consideration and revoke the bond of the defendant until such time as he can have a trial or his case can be resolved. Thank you.
Mr. Lockhart?
Only thing I would request is that he knows he's got a fair to appear out anyway. I advised him to come on in. I would request that I be allowed to file my motion to reinstate as to this bond and set aside the failure to appear on the other charge, and that I'll be allowed to have that set on the 30th of this month. I mean, it's pretty clear in these circumstances, the court's going to revoke his bond, but I'd still like to address both of them.
Well, based on the statute that we're dealing with, it doesn't require that the defendant be convicted of the charges. Rather, it states that if the defendant is released upon a personal recognizance, unsecured personal bond, or other bond approved by the court, the defendant violates the condition of release, is charged with an offense committed while during the defendant's release from the or other factors, then the court may revoke and terminate the defendant's bond and order the defendant held without bail pending trial and without release during trial. court finds that the evidence, the credible evidence in the court's opinion that have been produced is that the defendant did commit new offenses in this situation. Certainly, there's no question that he missed a court date and there is a warrant for his arrest to be held without bond. And therefore, I revoke this bond. I grant the state's motion. Mr. Lockett certainly has the ability to file whatever motion he wants to try to rehear these matters on the 30th, depending, and including the motion that he might file on his failure to appear. But as far as this motion today is, the court grants the motion.
Thank you.
Mr. Brewer will be in custody until the 30th when we hear those matters again. So. I think that concludes our business for today, so we stand adjourned. I've got some things to sign, so we need to.
All right, she wants you to send you something good. Okay. So, looks like I don't.
Thanks.
Thank you. The transfer order for Timothy Austin from today. That's that he and they talked about earlier. That was supposed to go 3 days. Thursday, we will need you because we've got motions in another Thursday. I think, what motions are we doing Thursday? That's just a corrections order. Line is at the bottom. You would think that I would remember it just a minute ago. I just got out of jail last week.
Good memory.
Well,
Here it is.
it's not what it used to be.
There you go.
Thank you, sir.
It's not photographic.
It used to be way better.
Well, with our trial tomorrow being continued, and the next thing will be those motions that we have on Thursday.
Yes, sir.
See you then, Judge.
All right, we stand adjourned.